With your permission, sir. Good afternoon, respected dignitaries. I have the honor to welcome all members of this August gathering to the special lecture session. This event is marked by the presence of distinguished luminaire, Honorable Mr. Justice Abhay Srinivas Oksa and Honorable Mr. Justice Ujjal Bhuyan, judges of the Supreme Court of India. At NLUJAA, Assam, the endeavor has been to foster an academic environment that goes beyond conventional learning. Through events such as these, we strive to create discursive spaces that encourage intellectual growth, critical thinking, and reflection in order to animate and enrich NLUJAA academia. Today's lecture is an important reinforcement of this tradition of the university. We are honored to have the opportunity to host this session, which would assuredly live and imprint on the academic enterprises of NLUJAA, Assam. To formally commence today's session, I invite our esteemed Vice Chancellor, Sir, Professor Dr. KVS Sarma, to deliver the welcome address.
Good evening, esteemed lordships, faculty, registrar, assistant registrar, and my dear students. It is my distinct honor and privilege to welcome you all to this prestigious event. Today, we have the rare opportunity to hear from one of the finest legal minds of our time, Honorable Sri Justice S. Abhay Srinivas Oksa, Judge, Supreme Court of India, a distinguished judge of the Supreme Court of India. His Lordship has made an indelible mark on the legal landscape through profound jurisprudence, unwavering commitment to justice, and a deep understanding of the principles that uphold the rule of law. His Lordship's judgments have not only shaped the legal discourse, but have also reaffirmed the values of fairness, equality, and constitutional integrity. As students, scholars, and practitioners of law, we are privileged to gain insights from someone who has played a pivotal role in shaping the legal system. His Lordship's lecture presents an invaluable opportunity to learn from his Lordship's experience, wisdom, and perspective on matters that influence not just the judiciary, but society as a whole. I welcome your Lordship to NLU Assam. Today, we are privileged not only to host an esteemed guest lecture, but also to have the honor of welcoming a distinguished Supreme Court judge, Honorable Sri Justice Ujjal Bhuyan, Judge, Supreme Court of India, who graciously gave consent to preside over the lecture. It is to bring to your Lordship's kind attention that the long-standing association of your Lordship with NLU Assam, as your Lordship has previously served as an esteemed member of University Academic Council and Executive Council, contributing significantly to institutional governance and academic advancement. Furthermore, during your Lordship's tenure as a judge of the Honorable Guwahati High Court, played a pivotal role in fostering the growth and development of the university in its institutional foundation framework. On behalf of NLU Assam, I extend our warmest welcome to your Lordship. I also welcome Honorable Sri Justice Mir Alfaz Ali, Director, Judicial Academy, to this lecture. To our faculty members, your presence today highlights the importance of continued legal scholarship and discourse. To our students, this is a rare chance to engage with the real-world application of legal principles at the highest level. On behalf of NLU Assam, I extend my heartfelt welcome to each of you. Let us make this meaningful and enlightening session. Thank you, one and all. Welcome. Namaskar.
Thank you, Vice Chancellor, sir, for this prefatory note. We harp on this opportunity to render our humble courtesy unto the distinguished guests of the university. I once again call upon Vice Chancellor, sir, to do the honors on behalf of the university fraternity. Kindly get the trees. May I now request Honorable Vice Chancellor, sir, to felicitate our distinguished guests, Honorable Mr. Justice Ujjal Bhuyan, sir. It is my distinct honor to introduce the distinguished speakers to the House. Honorable Mr. Justice Abhay Srinivas Okasa embarked on his journey as an additional judge of the Guwahati High Court of Bombay on August 29, 2003, and became a permanent judge on November 12, 2005. Lordship was appointed Chief Justice of the High Court of Karnataka in 2019 and elevated to the Supreme Court of India in 2021. Throughout his career, Justice Oak has been a strong advocate for civil liberties, environmental protection, and social justice. Known for his orders on protecting marginalized communities, Lordship's rulings have benefited slum dwellers, prisoners, transgender persons, and migrant workers. During the COVID-19 pandemic, Lordship has passed orders to protect the rights of migrant workers and has scrutinized the government's actions. His approach to public interest litigation emphasizes his role in promoting social change, and his judgments have strengthened the right of the urban poor, ensuring shelter and combating illegal evictions. Lordship has also championed the rights of prisoners, the secular fabric of India, and the right to legal representation. His landmark decisions on the right to protest manual scavenging and judicial intervention during COVID-19 pandemic are testimony to his commitment to justice. As an advocate for technology in the judiciary, Lordship has recommended automation in courts to enhance transparency and efficiency. Lordship's tenure reflects a deep understanding of law, impartiality, and an unwavering dedication to upholding justice, making him one of India's most respected legal minds. Thank you, Honorable Lordship, for your gracious presence amongst us today. Moving on. Designated as a senior advocate in 2010, Honorable Mr. Justice Ujjal Bhuyan was appointed as an additional judge of the Guwahati High Court in 2011, where he was confirmed as a permanent judge in the year 2013. Lordship later served as executive chairperson of the Mizoram and Telangana State Legal Services Authorities. In 2022, he became Chief Justice of the Telangana High Court and thereon appointed to the Supreme Court of India on July 14th, 2023. Lordship's judicial approach emphasizes the protection of human rights and the promotion of constitutional morality. Lordship has consistently upheld the principle that an accused must be given the benefit of doubt in criminal proceedings, ensuring that the standard of beyond reasonable doubt was rigorously adhered to, safeguarding the rights of the accused. Lordship has taken a strong stance in protecting the dignity, privacy, and equality of the transgender community. He has recognized that laws violating the rights of transgender persons, particularly those infringing upon their dignity and autonomy, are unconstitutional and should be struck down to uphold human rights. Lordship has espoused the importance of freedom of speech, asserting that public discourse, even on sensitive topics, should not lead to religious or communal tensions. His judgments addressing superstitions like witch hunting has condemned the practice as a gross violation of human dignity. He highlighted that such practices, rooted in misguided beliefs, result in severe human rights abuses and must be eradicated through legal measures and social reform. Lordship, thank you so very much for joining us today. I have the honor to call upon Honorable Mr. Justice Ujjal Bhuyan sir to present the presidential address.
My esteemed senior colleague in the Supreme Court, Justice Oak, Director of the Judicial Academy, Justice Ali, the Vice Chancellor of the Law University, Mr. Professor Sharma, faculty members who are present here, the Registrar of the Guwahati High Court, the Registrar of the University, Additional Registrar of the University, and my dear fellow students, my dear students. In fact, the focus today is to hear Justice Oak. So I will just lay down the foundation for a speech that will follow. In fact, I was here in September 2023 to deliver a lecture on the 50th year of the Keshavananda Bharati judgment. I remember that. Prior to that, before my transfer to Bombay High Court, I had come here on 1st of September. That was the NLU day here. So it's been I have been visiting this university. We met yesterday. A core committee has been constituted by the Chancellor, in which he has also included me. So I said that it's a national law university. It should be a center of excellence. And therefore, we need to do that extra bit to make it really, truly a national law university. We have pointed out certain things. I'm sure under the stewardship of the present Vice Chancellor, we will be able to do certain things. This university was established in 2011. Many national law universities have been set up thereafter. And it appears to me and to many others that they have stolen a march. The visibility of the university is very important. The enhancement of the university, the profile of the university is equally important. Therefore, it is a great fortune for all of us that a judge, a jurist of the standing of Justice Oak is before us. It is a great opportunity for all of us, in fact, to listen to him. When I went to Bombay in October 2019, Justice Oak had already left Bombay High Court as Chief Justice of the Karnataka High Court in May 2019. My colleagues in Bombay High Court used to tell me about the work ethics, work of Justice Oak. He used to travel from his own residence in Thane, reaching Bombay High Court, the High Court. It took almost 1.5 hours. He used to read the file both ways. And I started getting the opportunity to look into some of the judgments which he delivered in the Bombay High Court, including and one could find out his commitment to environmental issues. There's a famous case regarding the mangroves of Bombay, Navi Mumbai. Once you approach Navi Mumbai, you can see the mangroves. The orders were passed by the High Court that the authorities could not fell the mangroves without the permission of the High Court. That matter is still pending. Another matter came before us in Bombay High Court. There is a peculiar variety of litigation, genre of litigation. That's women, particularly vulnerable women, seeking the nod of the court for termination of pregnancy post the statutory period. And the High Court, on grounds which the High Court finds good and reasonable, permission used to be granted. There, I think Justice Oak is part of a bench which delivered a very seminal judgment on the right. And this, I think, is a precursor to this reproductive rights that we see nowadays. The right of a woman to have a say in the reproductive choice. After I came to the Supreme Court, I had the good fortune of sharing the bench with Justice Oak during the first part of 2024, from January to May 2024. And again, now this year, we are sharing the bench again. It's not necessary for me to repeat or speak about the judgment that has been delivered. A large number of judgments have been delivered. And these judgments are a testimony to the commitment to environment, to the commitment to civil liberties, to commitment to the secular fabric of the country, and a host of issues. So, and Justice Oak has been a standout judge of the Supreme Court. But as irony would have it, he has got a very short tenure left now. He's a judge of 2003 and became a Chief Justice in 2019, after 16 years. I'm a judge of 2011. I became a Chief Justice in 2022. That's the irony. That's how the system works in India. Therefore, and he came to the Supreme Court only in 2021, September. So perhaps it would have been better if we had a longer tenure of Justice Oak. Now, not only that, Justice Oak is also connected with the students, and he is the Chancellor of Maharashtra National Law University, Aurangabad, of which I am also a member of the governing council. So last February, we were there on one of the lectures about the Indian judiciary, about the constitution. The lecture was delivered by Arvind Dattar, the senior counsel, and the prefatory address was given by me. Justice Oak had delivered the presidential. So Justice Oak is not alien to the students' community. So therefore, he has been there interacting with the students. And in his under his stewardship as Chancellor of Maharashtra National Law University, the university has taken great strides and has advanced tremendously. So therefore, it is necessary that NLUJAA here must also, must be there in the reckoning with all the top universities, NLUs in the country. In one of his speeches in Pune, I think the recent speeches, Justice Oak deprecated the practice of having religious rituals in court functions. And in fact, he said that we should all bow down, if at all we need to bow down, we need to bow down before the Constitution or the preamble. In the Maharashtra National Law University at Aurangabad, we have the preamble in the entrance of the university, the administrative block. I would request the university authorities here also that we should have that preamble, an enlarged version of the preamble at the very entrance of the university, this administrative block. You are students of law. We are also students of law. Law is a continuing experience. There's no end to learning. And as students of law, our fundamental allegiance is to the Constitution of India. And the preamble represents the essence of the Constitution of India. Preamble is the window through which we can see what is there inside the Constitution, whatever is there in the preamble. And preamble gives the essence of what a liberal constitutional democracy governed by the rule of law should be. Therefore, as students of law, all of you must imbibe the culture of constitutionalism. You must read the Constitution. If not the Constitution, at least read the preamble and see to it that the philosophy behind the Constitution are maintained at least in the university campuses. As students of National Law University, it is expected that you should rise above narrow domestic walls, as the great poet Tagore used to say. You must rise above, and you must not allow narrow domestic walls to be constructed in between. As students of a National Law University, you must exhibit that wider perspective. You must exhibit a liberal thought process, a thought process which is wedded to the rule of law, wedded to the secular fabric of the Constitution. And I'm sure in the days and months to come, years to come, this university has the potential to be one of the top universities of the country. I see many bright students here. They are doing well as they have passed out from this university. We have a dedicated, committed faculty. Some of them have left, but it is a process which is there everywhere. In all universities is there. So I don't want to take much time. Like you, I also want to listen to Justice Oak, what he has to say. My best wishes to all of you, and I'm sure all of you will be successful in the endeavors that you take. Thank you very much, and God bless.
Thank you, Lordship, for the impassioned address, and many thanks to Lordship for providing such a graceful and insightful prolocution to the persona that is Honorable Mr. Justice Abhay S. Oksa. It is my privilege to invite Honorable Lordship to deliver today's special lecture.
My esteemed colleague in the Supreme Court, Justice Ujjal, Justice Ali, who is the director of the Judicial Academy of State of Assam, Dr. KVS Sharma, your Vice Chancellor, members of the faculty, and young student friends. as a judge of the Bombay High Court, thereafter as a Chief Justice of Karnataka High Court, and now Judge of Supreme Court, I keep on receiving invites to address on various issues. Now, my first preference is always to law schools and law colleges, because I believe that it is my duty as a judge of the constitutional courts to go to law schools and law colleges and to encourage the young law students, because young law students who are here today, or for that matter, any law school, they are going to future of Indian legal system. Whenever I come to any law school or law college, my mind goes back to 1980, when I was admitted to Government Law College in Mumbai, which is the oldest law college in our country. And then I realized that legal education has completely changed during the last more than 40 years. I remember when I joined Government Law College, on record, we used to have 3 lectures per day, only 3 lectures. And I found that we used to have actually 2 lectures per day. So 50 minutes was 50 minutes. So our education was limited to 100 minutes per day. And those were the days where we used to have only one moot court competition in every year. We had not even heard about mock trial competitions and other competitions. And we had professors who were mostly part-time professors. They're all practicing lawyers. And we had only 1 or 2 full-time professors. So really, our learning came from somewhere else and not from the law college. The Government Law College had a great advantage of its location. Bombay High Court is at a walking distance. And in those days, there used to be a British Council library very close to Government Law College, again at a walking distance. I'm talking about 1980, when we were not even aware about what is the meaning of video films. So the British Council library used to display video films every day. So after we used to finish our lectures, we used to go and visit British Council library, see beautiful films on Second World War. And there was such a huge library there. There are so many books about legal personalities. In fact, that library introduced me to Lord Denning and his beautiful books which he has written. And one was Bombay High Court, second was British Council Library. And third, another important place was Wankhede Stadium. Wankhede Stadium was at a distance of 2 minutes walking distance from Government Law College. Even today also at the same place. And remember, in those days, we could purchase ticket worth ₹1 and see Gavaskar, Vishwanath, Chandrasekhar, Irapuli Prasanna, and all greats in action by spending only ₹1. Because those were the days when IPL was not there. There was no one-day cricket. Only Ranji Trophy and Dulip Trophy tournaments were there, and Test cricket was there. So the emphasis which I want to make today is, now you belong to a very lucky generation of law students. You have very modern facilities of education in law. You have 5 years course. In fact, in those days, we never heard of 5 years course. In fact, to be candid with you, in 1980s, the popular conception was that one who could not get admission to any professional college or any better course, and last resort used to join law. But I must hasten to add that I was not one of them. Law was choice for me. But that was the perception in those days, that if you don't get admission anywhere else, you can join the law college, because getting admission in law college was very easy. But with the advent of 5 years course, which came in 1990, I must say that now the talent has come back to the law. 1990 was the beginning when in some of the states we started these 5 years degree courses. And the turning point was national law universities, which are established by various state governments. It started from Bangalore. And someday you must read fascinating story how the National Law School at Bangalore was established. Professor Madhava Menon was the first vice chancellor. He himself told me that initially government did not give an infrastructure. So the National Law School at Bangalore was started from a garage. And now today you see it has grown like anything. So most importantly, which I want to convey to you is that all these national law schools are established on land given by the government. All the national law schools are established and they are run out of the funds given by the government. So ultimately, it is public money which is used and which is still being used for running the national law schools. So therefore, when public money is used for running the for setting up of national law schools, for running the national law schools, naturally, state expects something from the students of national law schools. Now, what is the expectation of the state? That the bright young students must contribute to the existing legal system. They must become part of the existing legal system and they can be really part of that system to ensure that justice is delivered to the common man. And that's the expectation, legitimate expectation of the state. I was talking about legal education in 1980 and legal education today. One more very important change which I see. I have been associated with National Law School at Mumbai. I've been associated with National Law School at Aurangabad in Maharashtra. I was not exactly part-time lecturer, but guest lecturer in 2 or 3 law colleges in and around Mumbai. The biggest change which I have seen is now we have very bright and intelligent law students. In fact, I always enjoy the question and answer session with the law students because they are simply amazing. The talent which you people have is simply amazing. I must confess that we, in 1980, we did not possess such talent. We did not have that depth of knowledge. And it took us quite some time for us to pick up law after joining the profession. But I really admire the hard work which you, young generation of students, especially those who are students of National Law School, I really admire that because even the CLAT is so tough. You have to be really prepared to go through the CLAT and ultimately you will end up in good schools. What I want to emphasize today is that you must give back to the nation because ultimately this is a public school in the sense that the public money has been used for building this school and for running this school. I want to tell you for benefit of young students, my brother Justice Ujjal Bhuyan referred to the preamble. There is one article in Constitution, Article 51A, Clause 1 of Article 51A, which lays down the fundamental duties. The most important is Clause 1 of Article 51A, the first clause of Article 51A, which says that it is the duty of every citizen to abide by the Constitution. And second is to respect the ideals of our Constitution. Now, what are the ideals of our Constitution? You don't have to read the entire Constitution. If you go through the preamble, you'll immediately realize what are the ideals. Those ideals are set out. One of the most foremost ideal is that secularism, then there is liberty, then there is equality, there is fraternity. These are all ideals of our Constitution, and it is our duty to respect those ideals and to abide by those ideals. Talking about career in law. Now, many students feel that they should have career in what is known as commercial law. Now, commercial law will include company law, it will include IPR. And students get fascinated because of this commercial law. I want to tell you with great deal of emphasis is that the number of cases falling in the category of commercial law in our country are not even 5%. 95% of the litigation is the mainstream litigation, that is namely traditional civil and criminal litigation, and the writ work, the work before the constitutional courts. It may be in the form of writ petitions, it may be in the form of quashing petitions under Section 482 of CRPC, it may be in the form of revision applications. So please remember that in our country, the mainstream litigation is the one which is before the traditional courts. Now, traditional courts will include our trial courts and district courts, high courts and Supreme Court. Then many students feel that it is easier to get into a firm after they pass out. The reason is that when you get into a firm, you start getting income. You start getting reasonable income immediately. And many young students, they feel that they don't have background in the legal profession, and therefore they'll find it very difficult to initially survive in traditional legal profession and then to prosper. Here, I want to join issues with you. Yes, you are right that if you join firms, a law firm or any other firm, as I say, as a law officer, your income starts immediately. But you must remember one thing, that if you adopt a career in the firm, there are limitations on growth of your career. But if you join traditional legal practice, I can tell you from my own experience, I have been a lawyer for 20 years and a judge for more than 21 years. If you join traditional legal practice, you must remember one thing now. I have been attending conferences of chartered accountants, doctors. Everybody talks unanimously that legal profession is the most lucrative profession in our country. It's not a medical profession. It's not about the profession of chartered accountants or tax consultants. Legal profession is the most lucrative profession. If you join legal profession, traditional legal profession that is practiced before the traditional courts, initially, yes, you will face great deal of difficulties. But you must always remember one thing. If you are prepared to work hard, the work will come to you automatically. You must have read autobiography of Chief Justice M.C. Chagla, Roses in December. Justice Chagla has said that nothing succeeds in success like legal profession. Because once you succeed in legal profession, then you have to deal with various branches. Then you deal with cases of medical negligence, you deal with engineering contracts, you deal with intricate issues regarding accounting. So once you succeed in the profession, there is nothing like success in the legal profession. And those who have succeeded in profession, you must read their stories and you will know that everyone who has been successful, who was a first generation lawyer, he has seen very hard days in practice. I can give you several examples. First and foremost, I'll start with Nani Palkiwala. Nani Palkiwala belonged to a very ordinary family. His father had a small business. He had no background in legal profession. But look at Nani Palkiwala. He has given us a great judgment in the case of Keshavananda Bharati. I can give you several examples. Going back to Chagla's book, you must read that book. It's very interesting. Justice Chagla was junior to Muhammad Ali Jinnah, a father of Pakistan, as they call him. And Justice Chagla has mentioned in his book, Mr. Jinnah was practicing on the original side of the Bombay High Court. You know the system there. On the original side, the counsel are briefed by attorneys, solicitors. That's the practice. Practice continues for years together. So Justice Chagla used to sit in the chamber of Mr. Muhammad Ali Jinnah, and many solicitors used to come to him with some brief. Jinnah used to tell, no, it's a very small matter, I won't accept. Then the solicitor used to ask him that, sir, can you suggest any name? Jinnah would never suggest name of his junior. And junior was none other than Mr. Chagla. In the book, Justice Chagla has mentioned that at one point of time, he faced prospects of starvation, but he continued very diligently, and he became one of the most successful lawyers in Bombay High Court. And as you all know, he became a judge at very early age, and ultimately, he was the first Indian Chief Justice of any High Court. On 15th of August 1947, he became the Chief Justice of Bombay High Court. So there are many inspiring stories. So please don't be under impression that because you don't have legal background, you will not succeed in traditional legal profession. There are enough opportunities in traditional legal profession. And I have been discussing with young law students. If you join a company or a firm, I'm not talking about law firm, as a law officer, maybe initially you feel that, yes, you have good salary, reasonable salary, good perquisites. But then as you grow old, you continue to be only law officer. Perhaps your destination may get changed. Instead of law officer, they'll call you a law manager. or law, chief executive officer law, or some enhancement you get in your pay, but you continue to be ultimately a law officer. And then meanwhile, you will find that your friends who have joined bar, they prosper in 7 years or 8 years. So my appeal to you is that please think of joining legal profession. Now, when we talk about legal profession, wherever I go, one question is asked to me by young lawyers, young law students, and even young lawyers do that. 3 days back, students of 2 law colleges from Maharashtra, they had visited the Supreme Court. They had round up Supreme Court. They observed the functioning of the Supreme Court. In the evening, one of the registrars requested me to have dialogue with them. So practically 8 to 9 students asked me a question that, sir, how we can start practice in constitutional court, either High Court or in Supreme Court. And then I realized that they have wrong notion. Now, one wrong notion is that practice before the constitutional courts, that is namely before the High Court and Supreme Court, is superior to practice before our trial and district courts. This is completely a wrong concept. The practice before our taluka and district courts is as important as practice before the High Court and Supreme Court. Because you must remember that trial courts and district courts are the courts of first instance. I'll give an example. Suppose a litigant approaches you for filing a suit, say a suit for recovery of money based on a contract or a negotiable instruments. The most important thing for the litigant is that plaint has to be properly drafted. Now, plaint is to be drafted by a lawyer practicing in the trial court. Now, if there are inherent defects in the plaint, it is very, very difficult to rectify those defects. And then comes the trial. If the examination chief and cross-examination of witnesses is not properly conducted, the fate of litigant gets sealed there. I'll give an example of a criminal case. Now, in criminal case, if the prosecution witnesses are not cross-examined properly, the omissions and contradictions are not brought on record. Even if the accused, who is ultimately convicted by the trial court, he engages best possible legal talent in the High Court and Supreme Court, he would never succeed. Because the lacuna in the cross-examination cannot be filled in by High Court or Supreme Court. So please remember one thing, the practice before the trial court is very important. It is as important as practice before the constitutional courts. And in fact, it is more challenging because practice before the trial court, you need to have a very sound knowledge of human behavior because you deal with litigants, you cross-examine the witnesses. And, it's not simple. Now, I give you example of a suit for money, recovery of money. I'll give you one more example. If a suit is to be filed for enforcing a contract for sale of immovable property, sale of a landed property, drafting plaint is not easy because when you start drafting the plaint, you have to imagine that who are going to be your witnesses. Suppose there is possibility that defendant will deny execution of the document, or he will say that document was only for namesake, the real transactions were different. Then you will have to understand now who are going to be witnesses, whether the attesting witnesses to the agreement are going to support you. So you have to understand who are going to be the witnesses. Only if you imagine who are going to be witnesses, you can draft a plaint in better manner. Now, same is the case with criminal case. You have to decide what defense you are going to make. Suppose you are a lawyer who is briefed in a simple case of theft, section 279 of IPC. Now, when litigant comes to you, when trial is going to begin, it's very, very difficult for you to decide what should be the defense. Whether defense should be of total denial or whether defense should be that he has been framed and real accused is somebody else. Or line of defense should be such that you want to rely upon the lacuna in the prosecution case. Unless you are very sure about the line of defense, you won't be able to defend any criminal properly, any accused properly. And for this purpose, you need application of mind. You need to know how the human beings behave. And it's really a challenging thing to stand before the court and to cross-examine a witness. You require lot of thinking ability. You require a lot of patience. You require intelligence. It's not about fighting with the judge. I'll give you my own example. When you practice in trial court, for that matter, any other court, you need to develop what is known as court craft or advocacy. See, art of advocacy is completely different. It is not about your oratory skills. It's not only about your knowledge of law. It is something more. I'll give an example. As a junior lawyer, one litigant came to me. There was a money suit filed against him. It was based on 2 promissory notes. And perhaps he had no defense. Therefore, he came to a junior lawyer. I was not even 1-year-old lawyer there. So he came to me. Then I drafted written statement. Since suit was very small, it was taken up for hearing immediately. Then I started asking questions in the cross-examination. One after another, all questions were rejected, negatived by the trial court judge. And the practice in the trial courts is very peculiar in Maharashtra and many states, that if you ask a question to a witness and just says disallowed, then you have to give an application in writing and seek permission of the court to ask that question. So judge gives ruling on that why this question is not relevant and why is not allowing. So one after the other, I started asking questions. All questions were rejected by the court. Fortunately, the lunch recess came. Lunch recess intervened. There was one very senior and eminent lawyer sitting in the court. So he could see expressions on my face, completely lost expressions on my face. I was so diffident. He said, "Arey, young man, come to me. I'll entertain you with a cup of coffee." So he took me to canteen. And he said, "There's something known as an art of advocacy." He said, "First question which you asked, just said no. Instead of fighting with the judge and making an application, you should have said, your lordship is right or your honor is right. No harm in saying that. Then go to second topic, go to third topic. And then after half an hour, you can ask the same question in a different language. You formulate it differently, the judge will definitely allow it." So first lesson which I learned was that no purpose is served by taking on the judge. Ultimately, what is art of advocacy? Art of advocacy is art of convincing the judge that your client has best possible case, though he may not have actually in terms of law or on facts. So that's the art of advocacy. It's very fascinating. Your job is not to, antagonize the judge. Your job is to ensure that you communicate or convey to the judge that your client has best possible case. So coming back to the advocacy in trial court, don't have this concept that practice before the trial courts is inferior. I'll give one greatest example. Ram Jethmalani, you must have heard name of Ram Jethmalani, arguably one of the greatest lawyers which our legal system has produced. Mr. Ram Jethmalani used to regularly appear in Bombay in Metropolitan Magistrates Court, though he was in great demand before the Supreme Court to conduct all leading criminal and civil cases. But practically once in a week, we used to find him in some magistrates court in Mumbai. So when it comes to law practice, no court is inferior or superior. And, everybody won't be able to practice in the High Court or Supreme Court. Some of you must practice in the trial court because trial court needs very good lawyers. And when it comes to income, the commercial part of it or the practical part of it, today we have a scenario barring very backward states. Even in Assam, the fee structure should be good at district court level. I mean, if you are good in profession, the litigant will be willing to pay you. So therefore, please remove this impression from your mind, because I'm sure you are from different states. You don't belong to Assam. Remove impression in your mind that everybody has to end up in practicing before the constitutional courts. And please remember one thing, that in terms of provisions of appeal or revision, these trial and district courts may be in that sense subordinate to the High Court. But in true sense, they are not subordinate. They are the courts of the common man. Now, two things about the practice before trial court. Now, in India, in any court you go, the majority litigation is criminal litigation. And in criminal litigation, you get great opportunity to uphold freedom of individual. The freedom is guaranteed, the liberty is guaranteed under Article 21. So there are cases and cases you will find that a person is implicated in an offense, though there is no legal evidence against him. There are cases of false implications. So only those who practice in the trial court, they will be able to give real justice, because ultimately on a preamble, justice has been guaranteed to every citizen. So when it comes to giving justice to the common man, trial court lawyers play a great role. Ultimately, what was the dream of the framers of the Constitution? The dream of the framers of the Constitution was that every single citizen of this country must get justice, and that justice is available at the threshold before our trial and district courts. And one more thing which I want to tell you, I am the one who has criticized our legal system on public platforms. There are huge delays. The cases are not being decided within reasonable time. But one thing you must be proud of is that as far as our justice delivery system on the criminal side is concerned, it is one of the most fair systems in the world. The reason is you must understand the difference between Article 19 and Article 21. The fundamental rights under Article 19 are available only to the Indian citizens. But Article 21 applies even to those who are not Indian citizens. And therefore, the framers of the Constitution had this great thing in mind, that will uphold right to liberty under Article 21, not only of our citizens, but everybody who is residing on territory, who is part of the territory of India. And therefore, we always proudly say that the terrorist Ajmal Kasab was given a very fair trial by our system. In Bombay High Court, when his appeal came, his death sentence confirmation came, a very distinguished senior lawyer was appointed to defend Ajmal Kasab, because we believe in having very, very fair justice delivery system on the criminal side. So one is practice before the trial court, and one is, of course, I always say that you must practice before traditional courts like trial courts, High Court and Supreme Court. And that is what the expectation of state is from you, because the state-funded university, the state must get back good lawyers practicing in traditional courts. There's one more issue which I want to emphasize. That one is, of course, career in firms. There'll be career in corporate sector. There'll be career in traditional legal practice. But there are two other careers which are available. The first career is career in academics, career in research in law. I have been discussing with these issues. I meet many real experts in the field of law, and everybody is unanimous about one thing. In our country, there is nothing like true legal research. The research happens only for the purposes of writing a thesis for doctorate. So this field of making legal research is available. And India needs people who will make real research. And one more thing, now some of you must become academicians also, because if you want good lawyers in our country, if you want good legal professors in the country, we must have good teachers. And now profession of teachers is also, they are paid very reasonable salary and remuneration. So some of you must aspire to become teachers also. And the last thing in the career, there is career in judiciary. Maybe you are young, you may not be aware about what exactly is judiciary. Maybe you are misguided by some of your seniors by telling you that don't join judiciary. The reason is that service conditions are poor. But now during last 4 to 5 years, the things have undergone a great change. Now, do you know that a young law graduate who has not practiced even for 1 year before our courts, if he is appointed as a civil judge, he gets much more salary than what IPS or IAS officer gets to begin with. If you compare the entry point in judiciary, you enter the judiciary as a civil judge. So If you compare the salary and perquisites, which a civil judge gets it, with the salary and perquisites of newly appointed IS and IPS officer, the judiciary stands much ahead of them. And this has happened during the last about 7 to 8 years. We see a great change. About 10 years back, I was chairman of the selection committee of judicial officers of Bombay High Court. And we found that young law graduates were not joining judiciary. So we made some kind of a study. I'm talking about 2016 or 2017. What we did was, we went to the standard good engineering colleges in the state. I'm not talking about IITs or NIITs. They're really top class. So we went to normal standard engineering colleges and we inquired, and good engineering college, we inquired what kind of salary is being offered in campus interviews by very good companies. And we deliberately went to those colleges which are very well known in IT field or in computer technology field. And we inquired about it. Even at that stage in 2016, we found that what was the salary offered by top companies to these young engineering graduates was much lesser than what is offered to a civil judge. Now, I can tell you for your benefit, pan-India, this is a pan-India position, that a civil judge now, after judgment of the Supreme Court, 2 judgments of the Supreme Court, now even if you are a law graduate, you have done your LLM and you have certain percentage of marks in LLM, even if you are not practiced for a single day, you can enter judiciary. And today's scenario is, if you enter judiciary as a civil judge at the age of say 26, 27, the first pay packet you will get in your hand after deducting all taxes will be of 95,000, which is much more than any other engineering graduate, even IS and IPS officers get. And in addition to that, you get rent-free accommodation, you get petrol allowance, you get driver allowance, you get allowance for educating your children. So service conditions are far, far better now when it comes to joining judiciary. So I will always request all of you to consider option of joining judiciary. And there are a number of girls here. And now, when I talked about change of scenario in our legal education, now last 10 years, I must have presided over prize distribution functions of moot courts or mock trials. Now, without exception, I find that all winners are girls. Only by exception, some boys win few prizes. There is one more remarkable change which I have seen during last 10 years. Now you go to any state, at the entry point in judiciary, now we find that 50% are our women judges. And for women, it's a very good career in the sense that once you opt for that career, maybe after 3 years or 4 years, you'll be transferred. But it gives you a lot of stability. Initially, when you are appointed as a civil judge, it has better work and life balance as compared to life as a lawyer, because if you're a junior lawyer, you have joined some chamber, your senior will expect you to be there from early in the morning till late in the night. He'll expect you to come to his office on Sundays also. So there is better work-life balance if you join judiciary. So it's a very, very important field for women. And I must say that these women are doing phenomenally good job, those who enter judiciary. Apart from salary, apart from the kind of work which you do as a judge, there's one very important and fundamental thing which I want to share with you. As I said, I have worked as a lawyer for about 20 years and judge as 21 years, 21 and a half years. One thing I can say with great deal of satisfaction, that with a great deal of responsibility, that the work satisfaction which you get as a judge can't be compared with work satisfaction you get as a lawyer. I'll give you the reason also. See, if you are a lawyer, you may be a very good lawyer. You may be most well prepared dealing with a particular case. But the result of the case doesn't depend upon your skill or your preparation. You may be having a very difficult opponent. You may be having a hostile judge. There are various factors which control what you do as a lawyer. But as a judge, when you sit on the dais as a judge, nobody can control what you want to do with a particular case. You will be guided only by the correct legal position and your judicial conscience. Nobody can control what a judge can do while sitting on the dais. And it is because of this one factor that you get enormous satisfaction while acting as a judge. When you see you are able to do justice to common man, for example, simple cases, I'll give you an example. Take a case of a destitute woman who is driven away by her husband from the matrimonial home. If she appears before you, if you are able to ensure that she gets maintenance, say of 25,000 or 10,000 per month, that gives a great satisfaction that a woman who was thrown on the street, it is because of your judicial order, now she is going to survive, she is going to live life. So it's a satisfying job as far as career in judiciary is concerned. But as I said, we need good trial lawyers. We need good lawyers practicing in our high courts and Supreme Court. We need good academicians and we need good judges. And one more branch, which I must tell you, we need good government law officers also. Because unless there are good government law officers like prosecutors, now every day we discuss that the crime rate in India is on rise. That is true in practically every state. Now, if crime rate is on rise, unless we have good prosecutors who will be able to conduct the prosecution properly, there won't be any conviction. And if there is no conviction, there is no deterrent effect. The crime rate will keep on increasing. Therefore, we need good government advocates, good public prosecutors who will be able to So therefore, my advice to all young students is please don't look only at commercial world, because there is something beyond commercial litigation. Arbitration litigation, for example. I include arbitration litigation, then intellectual property litigation and traditional commercial litigation in the category of commercial litigation, which will include even matters under IB code also. But I assure you that in our country, they are not more than 5% of total litigation. Therefore, when you are in such a good institution, there's a good setup here. Now, please think about your future, please. And when you think about your future, please think about the legal system. And please think about the constitution. Constitution is 75 years old. Unless we have good lawyers and good judges who are part of our legal system, we will be never able to achieve the dream of the framers of the constitution. And what is the dream of the framers of the constitution? That is there in the preamble. So I think I have exceeded my time. My emphasis today is to encourage you to do something for the sake of legal system. And when you do something for the sake of legal system, you do it for common man of this country. Because ultimately this constitution, the entire government machinery is meant for benefit of common man of this country. So please keep this in mind. I know that all of you are really brilliant. I interact with many interns. I have about 5 interns in every month in my office. I must tell you that those interns who come to me, they have such a good legal mind. They are able to pick up the concepts, the intricate concepts of law so quickly. And I always place myself in their position. I always feel that, if in about 40 years back when I was a law student, my understanding of law was very poor as compared to today's young students. So you are in that great position, an enviable position where you can really take off. So I thank the Vice Chancellor and your faculty members for giving me this opportunity to have dialogue with you. And I wish a great success to you. I know that many of you will pass out. They will start appearing before the court. In fact, I always tell some of the young students who win prizes in moot court. I always tell when I have actually, I was examiner in this moot court competitions, I always tell that good that I am retiring early so that these bright people will not come before me and they will create a very difficult position for me when it comes to deciding cases. So please give justice to your bright legal minds. Please give justice to potential in you. And I wish a great success to you wherever you go, whichever branch of law you go. I wish a great success to you. Thank you.
Thank you, Lordship. Spoken words have the potential to unfold new realms of understanding where one thought could ignite 1,000 minds. Thank you, Lordships, for the